Hello and welcome to Courts Today by Live Law. Let us start with the headlines. In the Delhi air pollution matter, the Supreme Court has refused to relax GRAP Stage 4 restrictions in Delhi and highlighted lack of coordination among authorities. A plea has been filed in the Supreme Court challenging Delhi High Court's decision to confer senior designations on 70 advocates. In the wake of the Sambhal violence, another plea has been filed in the Supreme Court to stop surveying of the religious structures and to enforce Places of Worship Act. The Calcutta High Court has held that CCTV cannot be installed without consent of person in possession of the house. The Supreme Court is going to examine if the witnesses in the case against Tamil Nadu Minister Senthil Balaji are under pressure after him being appointed as a minister. In the Delhi liquor policy matter, AAP leader Manish Sisodia has moved the Delhi High Court against cognizance of ED's charge sheet. The Supreme Court has granted interim protection to journalist Mamta Tripathi in Uttar Pradesh Police FIR over the alleged defamatory video report. And the Supreme Court has stayed contempt proceedings in the Gujarat High Court against a judicial officer. I am your host Urvashi Chauhan with your daily roundup of legal updates from across the country. Let us get to the details. The Supreme Court today heard the Delhi pollution matter as the bench of Justices Abhay S. Oak and Augustine George Massey has been continuously reviewing the same. The court refused to relax the restrictions under GRAP Stage 4 imposed in Delhi. The Air Quality Management Commission had proposed some relaxations, highlighting that the GRAP 4 measures were very disruptive. But the court said that it would take a call on the relaxations on 5th December and the relaxations would not be permitted unless it is satisfied that there is a consistent downward trend with respect to AQI figures. Also, the court noted with concern the reports filed by court commissioners which revealed alarming details. It observed that there is a complete lack of coordination among stakeholders including the MCD, Delhi Police, the Delhi Commissioner and the Pollution Control Commission. It said that it is the responsibility of the Commission to coordinate the activities of these entities to ensure the effective implementation of necessary measures. A new controversy has emerged in the Delhi High Court following the designation of 70 advocates as senior advocates on 29th November. The issue arose when one of the committee members, senior advocate Sudhir Nandarajog, resigned after the final list was released, claiming that it was prepared without his consent. The process of designation is governed by the Delhi High Court Designation of Senior Advocates Rules 2018. A committee for designation of senior advocates, currently comprising Chief Justice Manmohan, Justice Vibhu Bakru, Justice Yashwant Verma, Additional Solicitor General Chetan Sharma, and senior advocates Sudhir Nandarajog and Mohit Mathur, oversees the procedure. Earlier, the committee had shortlisted 71 names from over 300 lawyers after extensive interviews. The official notification featured 70 names. But various questions were raised when senior advocate Nandarajog resigned, saying that the final list was made without his consent. A plea challenging the designation process has now been filed in the Supreme Court. Today, when the matter was mentioned before the bench of CJI Sanjeev Khanna and Justice Sanjay Kumar, the bench declined oral mentioning and advised the counsel to circulate a letter for listing it. In wake of the recent controversies relating to Sambhal Jama Masjid and Ajmer Dargah, where surveys of these mosques have been ordered by trial courts to ascertain claims that they were built over structures belonging to other religions, a writ petition has been filed in the Supreme Court. The petition seeks to stop the surveys which are in contravention of the Places of Worship Act of 1991. The petitioner here states that the cases related to Ajmer Sharif Dargah, Bhojshala Sambhal Jama Masjid, Shahi Idgah Masjid in Mathura and Gyanwapi were spoiling the communal atmosphere of the country, and the Supreme Court should intervene to put a stop to all these cases. The petitioners argue that such litigations are barred by the Places of Worship Act, which mandates that status quo should be maintained with respect to religious structures as they existed on 15th August 1947. It further states that states should not be in such a hurry to execute the survey orders. Rather, the cases should be brought before the High Court and the Supreme Court so that the atmosphere in the country does not deteriorate. The Calcutta High Court has held that CCTV cameras cannot be installed on the premises of a house without the express consent of the person who is in possession of that house. Justice Tirthankar Ghosh further held that in cases where cameras had been installed without the permission of the occupant, they would be free to deactivate them in order to maintain their privacy. Let me tell you, the decision was passed in a plea filed by a woman who, after becoming estranged from her husband, moved to another flat which had cameras. This flat was co-owned by them. She said that the cameras were same as those in her matrimonial home where she was allegedly physically and emotionally abused by her in-laws. The opposite party said that the house belonged to his sister and she, being the owner, was free to install the cameras as she likes. But Justice Ghosh said that the presence of cameras would disturb the petitioner's privacy and therefore it is well within her rights to deactivate them. The Supreme Court has today expressed surprise at the fact that Senthil Balaji was appointed as minister in Tamil Nadu soon after he was granted bail in the money laundering case. If you recall, in September last year, although there was a prima facie case against him, the court granted him bail because of long incarceration since June 2023 and because there was no possibility of the trial starting soon. Few days after he got bail, he took oath as the minister in the cabinet led by Chief Minister M.K. Stalin. A plea was thus filed before the Supreme Court seeking to recall the judgment that granted him bail because, according to the plea, the witnesses would now be under pressure. During the hearing, Justice Abhay Oak today remarked and expressed surprise at this situation. He said that granting bail one day and seeing the individual assume the position of a cabinet minister the next day could give the impression that the witnesses might feel pressured due to Balaji's elevated status. The bench, however, refused to recall the judgment as the law laid down there was benefiting several other persons, saying that it would limit the scope of inquiry to whether the witnesses were under pressure. The bench posted the matter to 13th December. Stay tuned. Aam Aadmi Party leader Manish Sisodia has now moved the Delhi High Court challenging the trial court order that took cognizance of ED's charge sheet against him in the money laundering case related to the alleged liquor scam. You are well aware that Sisodia was granted bail by the Supreme Court in both ED and CBI cases this year. Sisodia has challenged the order on the ground that mandatory sanction to prosecute him was not obtained by ED in the case. Justice Manoj Kumar Ori asked ED to respond to this petition and has listed the matter for hearing on 20th December. Recently, the court had also issued notice on Kejriwal's plea against cognizance of the charge sheet over lack of sanction. Kejriwal's matter will also be heard on the same date. In another development, Justice Ori had stayed the trial court proceedings against Congress leader P. Chidambaram in the Aircel Marxist case after he challenged the cognizance of ED charge sheet on similar grounds. In the next update, the top court has today granted interim protection to journalist Mamta Tripathi in an FIR related to an alleged defamatory video report. This report is from September 2023, published by Dainik Bhaskar. After the FIR in this regard, a charge sheet was filed and she was called by the concerned magistrate. She approached the Allahabad High Court with a prayer to quash the criminal proceedings, but she was denied relief. Although the High Court did grant her liberty to seek bail and discharge before the trial court. She has now approached the Apex Court. Her counsel said that this was a case of pure harassment of journalists in the state of Uttar Pradesh, as every time she does a report, an FIR is registered. He said that Dainik Bhaskar stands by the story. The additional Advocate General for Uttar Pradesh government pointed out that Tripathi was not appearing before the trial court. She sought 1 week's time to place the entire facts before the court. Thus, the bench of Justices Rishikesh Roy and S.V.N. Bhatti granted the time and directed that meanwhile, no coercive steps should be taken against Tripathi. To remind you, earlier, another bench of Supreme Court had granted interim protection to Tripathi in another FIR registered over her articles alleging caste discrimination in the administration of Uttar Pradesh government. And lastly, the Supreme Court has stayed the contempt proceedings initiated against an additional senior civil judge by the Gujarat High Court. Let me tell you the whole story. The civil judge A.M. Bukhare, who is the petitioner before the Supreme Court, happened to witness an altercation between a husband and a wife. This was in November 2020. The husband was forcefully trying to snatch away the infant daughter from the wife. The wife, who is also a judicial officer, then lodged an FIR in December against the husband for the offences of cruelty, cheating, etc. The petitioner, that is the civil judge, said that he accompanied the woman to the police station as a neighbour and a witness. The police arrested the husband in December 2021, who was later released on bail. Then in April 2022, the husband filed a contempt petition in the High Court against the police officers alleging illegal arrest. In February 2023, he filed an application to add his wife, the petitioner and the public prosecutor as respondents in the contempt petition, alleging that they had abetted the illegal arrest. This year in March, the petitioner and the wife were both suspended from judicial service. And in September, the High Court allowed the addition of the petitioner and the wife as respondents in the contempt petition. Now, in the SLP filed before the Supreme Court against the order of the High Court, the petitioner has contended that he had no role in the arrest of the person and that he was only a witness in the FIR. It was contended that the Supreme Court's directions in the Arnesh Kumar case, which is a landmark judgment, were intended to bind the police officers and not a private individual. He also said that the application to add him as a party was filed beyond the period of 1 year limitation provided under the Contempt of Courts Act. Hearing this SLP, a bench comprising Justices B.R. Gavai and K.V. Vishwanathan has issued notice and has stayed the contempt proceedings against the petitioner. For more information on the cases discussed here, you can visit our website at www.livelaw.in. Your support means the world to us. So please do not forget to like, share and subscribe to our channel. You can support us by clicking the thanks button below our videos or by becoming a member for just 89 rupees per month.